Good morning, everyone, and thank you so much for joining us for our second to last webinar of this fiscal year. I want to welcome those who are coming back and the new people who are attending, and of course, all our wellness centers throughout Quebec who have joined us. I don't know if you're like me, but I'm very grateful for Zoom and not having to go out and face the elements of this extreme cold weather. As Brendan mentioned, please keep your microphones closed. Put those questions in. We will have a question and answer period at the end. And as you think of them, please put them in so you don't forget them. And Katia, our executive director, will be working in the background to compile them. And when it's time, she will be asking Natalia, our presenter, those questions, and we'll be able to hit the road running. First of all, without further ado, I would like to thank our funders, and that is the Secrétariat aux relations avec les Québécois expression anglaise for the funding that has allowed us to produce these webinars. And of course, we have an ongoing thank you to our partner, Québécois, who has always been a supportive partner in producing these projects and webinars for us. As Brenda mentioned, they will be sent out the link of the recording in approximately 10 days following today's session. And you will be also able to refer family members or friends who were not able to attend to view them in 10 days on seniorsactionquebec.ca website and also our YouTube channel. Now, without further ado, I'd like to introduce our presenter of today, who is a lawyer, Natalia Malone, who practices family law and civil litigation. She's received her political science degree from Concordia University and her law degree from the Université de Montréal. She also attended the Institut d'études politiques de Strasbourg, France, with a practice at the European Parliament. She is multilingual. Ms. Malone has pleaded before the Quebec Superior and Appeals Court as well as administrative tribunals. While Natalia favors mediation and amicable resolution of conflicts, she has represented clients successfully in highly mediatized and constitutional cases as well, especially in family law cases. Natalia encourages mediation and provides her clients with legal information needed in order to settle the matters favorably, thus avoiding years of court procedures, conflict, and expense. Natalia has her own practice, which is situated on Sherbrooke Street West in Westmount. Natalia, I have to thank you so very much for giving us of your time, your expertise and knowledge, and I look forward to hearing what you're going to tell us and advise us to do should we face a situation where we have conflict. We want to find a resolution for it, but we don't necessarily have the time, the resources, or maybe even a lawyer in order to help us. So I'm going to turn it immediately over to you. Thank you ever so much.
Thank you, Ruth, and thank you for having me. As Ruth just said, my short biography, basically I do a lot of civil litigation. That's my main practice with family law, so civil litigation, family law, and I had the opportunity to do constitutional litigation as well. And especially in family law and also in civil law, as you can imagine, there are a lot of cases that can be referred to mediation. And that is why I'm going to be able to give you an idea of what mediation is, and that court is far from being the only answer to any disputes or any litigation you might have at home or with your children or with your siblings, or maybe that your children could have with their neighbors. So we're going to talk about mediation. Now, let's start with the first slide, please. I am going to tell you about Joe. You see Joe there in the corner? He has a lot of problems. And Joe is one of the many people in Canada who reported experiencing at least one dispute or legal problem in the previous 3 years. Imagine that's more than 1/3 of the population living in Canada. And actually, that percentage has gone up. This is the study from 2021, which I referred to here. So legal problems are part of life. I enumerated a few: rental matters, disputes between neighbors, family issues, divorces, inheritance, litigation, employment problems, consumer protection, conflicts between business partners, etc. Now, to give you examples, concrete examples, it can be obviously a lot of cases are about divorces. Divorces entail, what do they entail? Custody issues. You can have issues regarding spousal support, child support, people arguing about their incomes, who's hiding money, who's not hiding money. Maybe they make more money than they declare, how they calculate child support, how much they're going to have to pay each other for spousal support, if that's the case. It's dividing assets. They argue about cars, about furniture, about houses, who put a down payment on the house, who put more. One of them paid for renovation of the stairs. The other one maybe bought the sofa, or the other one got as an inheritance a nice painting. These things are just everyday disputes that I deal with my clients every single day. Now, the issues, of course, with custody, they can be very emotional, but I want to tell you that even a matter of, I don't know, a painting or the sofa can become extremely emotional. So especially in cases that involve family, which does not have to be just divorces, but can be issues between siblings with an inheritance, or disputes between, for instance, grandparents and parents, so who don't want their children to see the grandparents enough times. So then I've already had clients who are grandparents who actually started legal actions against their own children, or let's say the son-in-law or the daughter-in-law, because they weren't allowing them to see their grandchildren. And they have a legal right, grandparents, to see their grandchildren. And so all of these cases can be extremely emotional, of course, especially involving kids, but even for a little thing like a sofa or a car, sometimes people prefer to just spend money, go to lawyers, go to court just to argue about something that really doesn't have much value. In context of separation, people become very emotional, which is understandable. And so they're willing to just do anything just to keep that sofa. So this is family law. But you have also, disputes between neighbors. You have, let's say, to give you an example, a case where the neighbor has lights, I don't know, they're very bright lights, which he likes to turn on every night at around 11 p.m. It disturbs my client. So imagine flashy lights. It just disturbs and they're willing to go to court for that, which again is understandable because, it interferes with their sleep. So anything you can think of can be a subject of dispute. I have a case where, of course, you have siblings arguing on inheritance. You can have some people who said maybe the will is not valid because they didn't get enough money in the will, and they're saying that the person who left the will maybe was not sound of mind. You have siblings basically who all say that, yes, the parent was sound of mind, but the siblings arguing because they inherited, let's say, a triplex. This is another case. I'm just giving examples of cases where they're arguing about how to divide the triplex because it's an undivided co-ownership and what's the percentage for each floor. And then they're arguing how to divide the expenses because there's no co-ownership agreement. So anything you can think of. Of course, I mentioned also consumer protection. Consumer protection is every day. You just buy a stove, it's not working, they refuse to replace it, they refuse to fix it, they say no, the warranty is already gone. You have conflicts between business partners. Imagine one of them wants to sell the shares, he has to offer them maybe to his partner first, he doesn't, he can get a better price somewhere else. It's basically it's anything. So I mentioned the fact that 87% of those with a legal problem will address it. That's a very high percentage. So most people are not just going to sit down and not do anything about it, but it doesn't mean addressing it does not mean going to court. I mentioned here what it is actually to address a legal problem. So it means simply getting informed. It can be to seek legal advice from a lawyer. It can be searching online for help. You can go for an association, for instance, or organization that can offer support. It's getting advice from family and friends. But this is just to show that only a very, very small proportion of those with legal problems go to court. So it's like 7% or even less that actually end up going to court. So most people choose to, seek legal advice from lawyers and maybe discuss. They try to resolve the matter amicably. They try to get answers whatever they can, basically. Now here Joe has a lot of problems. As you can see, he's extremely upset. And what does he do? Let's go to the next slide, please. He calls me. So you see here, Joe, he calls me. And I get these calls, as you can imagine, every day. Nobody ever calls me to tell me, hey, I'm doing fine. I just call you, Natalia. I just wanted to tell you that everything is going fine in my life. I just got your number from a friend just to say, hello, how are you doing? I'm very happy. Never. Every single time the phone rings, it's because someone has a problem. Okay, it's all about problems. Now, the first thing I do, of course, I listen to Joe, when he tells me I have problems. In this case, Joe was telling me that finally he decided with his spouse that it's the end of their relationship. After 35 years, unfortunately, they're going to separate. And they've been talking about it, they've been arguing about it, it's enough. And so he doesn't know what to do. So he calls me. And what do I do after hearing him out? Especially because it's a matter of family. Whether or not there are children, it doesn't matter. I tell him, listen, Joe, instead of going to court right away, because Joe immediately says he wants to go to court, because this is what usually people do. They're very upset. They're very emotional. I want to go to court. That's it. We cannot communicate. I say, no, Joe, please calm down. Okay, I'm going to tell you about something which is really going to help you. It's going to help your family. It's a better solution for everyone. You at least need to consider it. Okay, and what do I mention to him? It's mediation. It's not meditation, it's mediation. Now, what is mediation? Mediation is, as per the Code of Civil Procedure, it is one of the main private processes for dispute prevention and resolution in which the parties call on a third person to assist them. Okay. So this is actually, it's just an easy way of saying what the Code of Civil Procedure says. And I'm going to read you the article. It says the main private dispute prevention and resolution processes are negotiation between the parties and mediation and arbitration in which the parties call on a third person to assist them. The parties may also resort to any other process that suits them and that they consider appropriate, whether or not it borrows from negotiation, mediation, or arbitration. So, mediation is used to prevent disputes. So to give you an example, you have two shareholders. They have a company together. It's doing very well, but then they think of a scenario where, let's say, they don't agree they don't agree on the future of the company, and one of them wants to get out of the company. So in that case, the situation does not exist yet. But they don't want to get to that point where there will be a problem, and then they're going to be emotional and they're going to have to deal with it in a stressful way. No, they say, let's go resolve this now in case that situation ever happens. And so they can go to a mediator and with this scenario, and they're going to talk about it and come up with a solution in order to prevent this dispute from happening. So they're going to, let's say, at the end, if the mediation is successful, which very often it is, they're going to write an agreement and they're going to say, in case this happens, in case that happens, this is what we're going to do. And so it doesn't have to be a conflict yet. It's to prevent a dispute. Okay. So, of course, that the second situation is the resolution of disputes. And the resolution of disputes, of course, when there's already, especially in family matters, but again, it can be with tenants, landlords, it can be, like I said, shareholders, it can be anything, estate matters. So it's to get a solution for a dispute that already occurred. And so you're in the middle of dispute, you're going to see a mediator. Now, the mediator is for sure going to try to help you to resolve the matter. And so this is the resolution of disputes. And so if you look at the first article, it's just to show you how important mediation is and how not just mediation, but also arbitration and negotiations. It's the first article of the Code of Civil Procedure. So in 2016, actually, the legislator gave very, very much importance to already they were important, but they became even more important, these processes to prevent disputes and for resolution of disputes. They became extremely important. The legislator, look, it's in the first article of the Civil Code of Procedure. It says to prevent a potential dispute or resolve an existing one, the parties concerned by mutual agreement may opt for a private dispute prevention and resolution process. Okay. So it's right there, the first article of the Code of Civil Procedure. Now, is mediation mandatory or optional? Okay. The answer, of course, I'm a lawyer, so I'm just going to refer again to the Code of Civil Procedure. And it says, paragraph 3, also still in the first article of the Code of Civil Procedure, it says, well, parties must consider private prevention and resolution processes before referring their dispute to the court. And it says that it is voluntary. However, I will explain to you later, sometimes it is not. So you have to actually go for mediation. Look, parties, article number 2, parties who enter into a private dispute prevention and resolution process do so voluntarily. Okay, so parties must consider private prevention and resolution processes before referring their dispute to the courts, but participation is voluntary. Exception, small claims court if the object of the dispute is $5,000 or less. And so I was just saying that, of course, most of the time it is voluntary. However, in certain cases, you have to go for mediation. And that actually, again, the legislator is encouraging even more and more people to go for mediation, and it's even making it mandatory since just a few months ago. So now if the object of dispute is $5,000 or less and you go to small claims court, the government gives you basically mediation. It's a service. So you have to go there with the person that you're suing or the person who is suing you. You have to go for mediation. So what does that do? Well, it helps you basically, get your answer, resolution, much faster. Of course, the government helps the government because they don't have to pay a judge who's going to sit there and examine the file. And also, you have the delays are very long. You can wait 2 years to see a judge, even in small claims court. And so it helps everybody. It's a win-win situation. Next slide, please. So here's Joe. He listened to my advice and he went to see a mediator. So what is the process of mediation? Now, the first thing is deciding to go for mediation. I explained to Joe what the advantages of mediation are. I told him, listen, Joe, if you come to me, fine, we're going to start a legal action in this separation case, and you're going to be divorced because you're not doing it amicably right now. You're fighting about absolutely everything. You're going to spend a lot of money on court, on legal fees, on everything. Okay. And so I don't think it's in anybody's interest. It can take honestly about 2 years, I would say, even 3 years before you get a divorce judgment. It's going to be very long. We're going to have to go to court many times. And I don't think it's in your interest. So you really have to consider mediation. And he listened to me. So he actually went and he's there, and that's his wife, and they're there together with the mediator. In family matters, it is very important to point out that mediation is not mandatory in family matters. However, it is mandatory for them to consider mediation before they go to court. So if you start actually a divorce case and I have to draft the legal proceedings, I need to declare, okay, they have to declare that they consider going to mediation and that it did not work out. That for certain reasons, they decided not to go for mediation, but they need to have considered going to mediation. And me as a lawyer, when Joe calls me, I need to tell them, listen, you should really consider mediation. It's my obligation. As per the Code of Ethics, the Code of Civil Procedure, I have to tell them you need to consider mediation before we do anything, okay? And so here Joe goes to the mediator. He gets an appointment. How does he find the mediator? Well, he calls the barreau. You know, you can call the barreau. You can have an association of all the mediators who are registered mediators. And and the parties, as you can see here, he's there with his wife, of course. They need to agree on the mediator. So he cannot just choose the mediator alone and then force her to join him. It's not like that. So once they decide together to go see a mediator, well, together they're going to agree on one. So he can suggest one, she can suggest one, and then finally they have to agree on a mediator. Okay. The first sessions in divorce cases, separation cases are actually free. The government pays for them just to show you how much they encourage mediation. If there are children involved, you have more sessions that are free. You have like 5 sessions, I believe. And if there are no children involved, then it's like about 3 sessions involved that are 3 sessions that are free. And so after that, you just have to start paying basically the mediator. And of course, at these hours, it's not actually sessions, it's hours. And of course, you have to think the mediator is also going to work. And so, you know, it might require several visits and a few hours of work for the mediator, but it's worth it. Most of the time, it's worth it. Now, after you decide to go for mediation, after you find the mediator and the parties agree together on a mediator, well, they go to the mediator, and the first thing that they do when they're in front of the mediator, well, they prepare a mediation agreement. This mediation agreement usually includes the mandate that you give to the mediator. For instance, well, we're here to, you know, finalize our divorce. We don't get along on absolutely anything. We want to know who's going to take the sofa. We want to basically reach a settlement. We want to settle this amicably. Okay. And also, who will cover the mediator's fees? This also the agreement. Usually it's half-half. And that also shows that both parties want to settle the matter amicably. Sometimes they can say, okay, you're going to be the one paying, or I'm going to be the one paying, or you're going to pay more or less, according also to their income, so their financial capacity. The mandate also includes the agreement, how the information is going to be exchanged. And for instance, you're going to bring all your bank statements from 2013 to 2025. You're going to bring your the proof that you're the one who paid for, I don't know what, that you bought it alone before we got married, and that you got this as an inheritance. And so all those things are basically information that has to be exchanged in a separation. And so basically this agreement just says everything. We're going to exchange information, who's going to pay for the mediator, like I said. And one of the very important things that the contract has to say, the contract with the mediator, is whether or not, or how confidential these sessions are going to be. Now, I mentioned here, like you saw here in this slide, it says it is confidential by default. So mediation is confidential by default, and this is very important. When you go to mediation, even if there's no contract or it's not mentioned, by default, it is confidential. It's not confidential that you went to mediation. What's confidential, because most probably when if it doesn't work out and you start, legal proceedings, you're going to indicate we went to mediation, but it did not work. So that's not what's confidential. But you're not allowed to use absolutely any information that was exchanged during mediation. So that was exchanged, information that was exchanged, what was done, what was said, that, I don't know, he got up and left. You cannot say that. You cannot use any information that you received, any bank statements that you received, or any document, or that he said something that might help you in a law, in the law case, if ever it doesn't work out. And even if it does not work, let's say if it does work out, and you cannot mention it to friends, you cannot say what happened in mediation. It's just simple as that. That's confidential, okay? And you cannot use it against the other person. You cannot do that. And so if ever you go to court after that, if it doesn't work out, and again, it's just, you don't agree on child support, or you don't agree on, I don't know, custody, you don't agree on who gets what, you cannot use the information. And that's very important with mediation. But that's a very good point, actually. It's a very good point, because what does it do? It promotes transparency and promotes the exchange of information, of honesty. There are going to be no surprises. Everything, all the cards are on the table. Nobody's there to to surprise you, like when you go to court. At the end, you can always just get more information all of a sudden that can just change everything. Here, it's not like that. You're supposed to be completely transparent, and we're going to talk about your obligations as a participant later. So I mentioned here one of the points that the mediation agreement has to include is if a contract is signed, whether or not it will be homologated by the court. Now, this is maybe a small, I would say, minus of mediation. What is the small minus of mediation? Well, in case of divorces, for instance, or certain separation agreements, it's not enough to just reach an agreement with mediation. Okay? The mediation, the mediator does not make a decision for you. So he just helps you, he or she, they help you find a solution, get to some resolution or prevent a dispute. But once, let's say you reach a settlement, okay, well, once you reach a settlement, that settlement, for instance, in case of divorce, that's not a divorce. So the court still has to render the judgment of divorce. And so you have to basically, the mediator, for instance, if you give the mediator the mandate, can go with that agreement, and then the court still has to put the stamp, okay, here, and render the judgment of divorce. And so what it means when I mention here, and if the contract is signed, meaning if agreement is reached and the contract is signed, whether or not it will be homologated by the court. So homologated by the court means is the court, are you going to go to court to put the stamp on this agreement and make it mandatory, in the sense that if you don't do that, it does not have the force of a judgment. It's just a contract that, let's say, you and I sign, and we sign at home, and I will do this and you will do that, and then we hope for the best. Okay, I hope that you're going to respect it, and you hope that I'm going to respect it. But if we go to court and the court homologates the contract that we sign, so the court puts the stamp there, then it has the force of a judgment. So it's as if you had just gone through 3 years of legal battle, and then and then the court makes a decision. It has the same force if the court puts the stamp on it. And so you have to, before you go to mediation or in the mediation agreement, you need to decide if you want or do not want, after you reach an agreement, which hopefully you will, if you want the court to put the stamp on that agreement and make it executory, which means it will have the force of a judgment, or you're just going to go home and just hope for the best. It is a legal obligation. You have to respect the contract, but it's one thing to have, to shake hands and to have a contract, okay, we're going to do this, and another to have a contract stamped by the court that has the force of a judgment, okay, where you can even send the bailiff, let's say, to execute the judgment, okay. And so what does it entail? So deciding to go for mediation, finding a mediator, preparing the mediation agreement, and then, well, the meetings with the mediator. So how does it usually work? Well, first thing is there's a joint session with the parties. So you meet with the mediator. It's also when you sign the agreement and you talk about the objective and you talk about the situation. You explain what's going on, where the issues are, what you don't agree with. But of course, the purpose is to settle. We're here to settle. We're trying to, I don't know if we can reach an agreement, but we're going to try to. Can you please help us? And basically, it's the context. And after that, the mediator can suggest, or the participants can suggest, to have individual meetings with the mediator. So that's allowed. Even though you go together for a mediation, you can also have individual meetings with the mediator. So on Monday, you go together, and then the following Monday, only Joe goes with the mediator, and he explains, what his problems are. And I don't like the fact that she's like this, and the kids, she does this with the kids. I don't agree with that. She spoils them too much, and then one of them wants to go to university. I don't want to pay for the fees. If they want to go to university, I mean, they're already 20. If they're 20 years old, I should not pay for child support. She said she's asking for child support. And so what does the mediator tell him? Listen, Joe, even though your child is 20 years old, you still have to pay for child support if the child, for instance, is in university. Okay, just because your child is 20 years old, it doesn't mean that there's no more child support. As long as your child is dependent on you and goes and studies full time, for instance, well, you still have to pay child support. So the mediator will explain to Joe what his obligations are, what his rights are, but without, of course, taking his side. So the mediator is not there to take his side, but she can inform him of what his obligations are. Okay, and she's going to do the same with his spouse. Now, of course, at the end, you have joint sessions with the parties again. So they negotiate, they discuss, they both had individual meetings with the mediator. They were very fruitful. And now, of course, they're going to meet again and they're going to try to reach a settlement. And you can have several meetings together, several individual meetings, as long as it takes to reach a settlement. Now, reaching an agreement, that's the last basically step, signing a contract if needed. But sometimes a handshake is sufficient. So what does it mean? It means that not in every single case, for instance, if there's a problem between neighbors, you don't necessarily need an agreement like a written contract. An agreement is still an agreement, even if it's not written. It has the same consequence. If you and I decide now that you're going to do this and I'm going to do that, it's a contract. It doesn't mean that if it's just verbal, it has less legal value. No, your obligations as per a verbal agreement are just as important legally as written obligations. So a handshake sometimes is sufficient. You say, okay, I'm not going to turn on the lights at 11. I'm going to use a smaller light, and I'm actually going to turn them off by 11:30. So I'm going to maybe turn on the lights from 11 to 11:30, and they're not going to be that bright. And so the neighbors can agree on dispute, and you can do that for even if you have problems with your neighbors, or if you have problems with tenants. Now, of course, here I should mention the fact that if you have for disputes regarding landlords and tenants, you know that there's the Régie du Logement, which is now actually it's called the Tribunal du Logement. Now, the Tribunal du Logement offers actually conciliation session between landlord and tenant. It's not really mediation, but it's conciliation, but nothing stops you from going outside of that system and just looking for a mediator. So basically, it's up to you to decide if you want to see a mediator for any of your conflicts. So this is just the conciliation is offered by the Tribunal du Logement, but you can choose to go to a mediator to try to resolve the matter amicably if you wish so, even outside the system of the rental tribunal. So let's go to the next slide, please. Now, this is very important. What are the obligations of the parties? When you go to mediation, like I said, in certain very, very few cases, it's mandatory. Most of the time, it's voluntary. But if you go there, you do have obligations. Once you choose to go there, you cannot go there just, knowing, for instance, that you're not going to be transparent, or thinking your objective being, I'm going to go there with the objective of keeping some information to myself. I go there because if I go to court, I know I'll have to disclose this information. But if I go here, maybe I'm going to get away with it and I won't have to disclose everything. It's not like that. If you go here because you know that you're going to be of good faith, you commit to being good faith, you commit to being transparent completely as regards the information in your possession. And if you look at Article 2 again of the Code of Civil Procedure, it says that the parties who enter into private dispute prevention and resolution process do so voluntarily. And then it says they are required to participate in the process in good faith, to be transparent with each other, including as regards the information in their possession, and to cooperate actively in researching for a solution and, if applicable, in preparing and implementing a pre-court protocol. Okay? They are also required to share the cost of the process. Now, as you can see, if you go to mediation, you commit to being fully transparent. You also know, don't forget, which we mentioned previously, that this is completely confidential. So whatever you disclose here is not going to be used against you if ever this case goes to court. If you don't end up settling through mediation, they will not be able to use the information they have against you in court. And then here you might say, yes, but they will know, and they will try to, even if you go to court, straight to court, there are always subpoenas, there are motions, whatever, in order to get all the information you want from the opponent. But in mediation, you go there because you put all your cards on the table, and you know that, okay? And you commit to that. And I have to tell you something. If you don't do that, and let's say you lie about things, or you're not transparent, you don't disclose the information that's necessary in order to reach, in order for the other party to make a clear and informed consent, what happens is that if a year later or 2 years later, the person finds out that you actually had another property in the Bahamas that you did not disclose, or I don't know, anything, okay? You lied about a bank account. You had more money in your RSPs account that you actually disclosed, or you had another account that you just didn't mention. Well, that party can actually start legal proceedings against you 2 years later because you were not truthful and you were not transparent. You did not respect your obligation. So you do want to be completely transparent and honest during this process. What I mentioned here is also one of the obligations is to respect the principle of proportionality. Now, this is a term that we use in court all the time to such an extent that now it's part of my daily vocabulary, even at home. I tell my husband, you're not being proportionate. Okay, proportionality is very important. He says something, this is not proportional. I even tell my baby, you're not being proportionate right now. Your reaction is completely disproportionate. Okay, I use it many times every day. And so the participant and the mediator need to respect the principle of proportionality. And again, Article 2 of the Code of Civil Procedure says the parties, those who enter the private dispute prevention resolution process, so mediation, for instance, says they must, as must any third person assisting them, so the mediator, ensure that any steps they take are proportionate in terms of the cost and time involved to the nature and complexity of the dispute. And so that means that, let's say that we argue about the sofa, okay? Who bought the sofa? Was it purchased before the marriage, after the marriage? Now, if it was purchased before the marriage and the owner is saying, that's not true, we purchased it after we got married, you're not going to spend 10 hours of mediation fighting about the sofa. That's not proportionate, okay? So proportionality means you're going to argue about the sofa maybe for 20 minutes, or 15 minutes, not 10 hours. That means proportionality. So in terms of cost, in terms of time, proportionality, however, is also used in court. So it's not just mediation, it's also court. You cannot fight in court on small matters. Sometimes people are extremely emotional, as you can probably imagine, when they go to court, especially separation or matters involving siblings, parent, children, but even things that are not necessarily really personal. It can simply be landlord tenant. The people get emotional, and so they tend to spend a lot of time. It's very important to them. It's very important to them. But the mediator, just like the participants, have the obligation to respect the principle of proportionality, and so that ensures a process that's going to be not too long. Okay, so if you go for mediation, you should expect enough sessions to discuss the important matters, and without thinking, I'm going to spend 100 hours here if that's what it takes to resolve this matter of the sofa. No, we're going to use 10 hours or 8 hours or 15 hours, as long as it takes, but we have to be proportionate. Okay, so that's the principle of proportionality is very important. And right now, the courts mention it, like I said, all the time, because most often than not, one of the party is not proportionate. Very often, neither party is being proportionate. So that's the most important thing right now. If you go to court, you say, he doesn't respect the principle of proportionality. For sure, the court is going to agree with you. Now, the last thing, your obligation is to observe human rights and public order rules. Now, you cannot basically sign an agreement. To give you an example, what does this mean? It sounds very sophisticated, but it's actually something that is very common. So to give you an example, a public order rule is child support. Okay, child support is determined according to certain guidelines. The parties, when they go to mediation, cannot agree that he's not or she's not going to pay child support because it's okay, and the parties agree that there's going to be just no child support, even though there are means for it. It cannot be like that. That the public order rule is to pay child support when there's means for child support. And so the parties cannot go against this public order rule that there's going to be no child support. So this is just to give you an example of a public order rule that you have to respect. You have to respect public order rules in your agreement, even in mediation. You cannot, for instance, provide in your agreement that he can, oh yes, the other person, for instance, can't use me or make decisions for me that have to do with my life, or I don't know, like things that are already provided in certain laws that the public order laws. You cannot provide things in the agreement that go against these public order rules. So that's basically easy because normally the mediator knows these public order rules. So the mediator will tell you, no, this goes against public order rule. Of course, you cannot go against human rights. You cannot say, yes, you can beat me once in a while. So just to give you an example. Okay, can we go to the next slide, please? Okay, so the role of the mediator. Now, it's to open communication, negotiation between the parties. That's why the parties are there. But very often when they get there, they're usually very upset with each other. Usually when they go there, unless it's to prevent a dispute, like I mentioned previously, most of the time it's to find resolution to a dispute. And when they go there, they're very upset with each other. Maybe they haven't even been talking for a long time, or they just scream at each other. And so the mediator's role is to open the communication, to establish, calm, and start the negotiation. And the mediator says, well, what's your objective? What's your objective, first of all, here? Let's talk about what's your position, what's your point of view. And then he asks the other person, and then what exactly do you want out of this? What do you think the other person's view is on this? They're going to also tell them what their rights and obligations are, because very often people don't know. Very often the reason why there's a dispute is that people are not aware of their obligations. And so they're actually taken by surprise. They're taken aback when you tell them, no, but this is actually an obligation that you have. To give you just like the simple example that I gave you with the child. So child support, very often, Joe calls me and he says, I don't have to pay child support. What do you mean? My child is 20. He says, yeah, but you just told me that he's doing a bachelor's in computer engineering, didn't you? Yes. And I said, and he's doing it full time? Yes. And does he work? No, or he works 10 hours or 5 hours a week. Well, I'm sorry, Joe, but this child is still dependent. And so you do have to pay child support. Okay, so just to give you an example, people don't know what their obligations are or their rights. And so this is a very common reason for dispute. So the mediator, of course, will come up with options. We're going to do brainstorming, of course, encourage dialogue between the parties. We're going to try to think out of the box sometimes. If someone owes the other party, I don't know, an amount of money, $30,000, I gave you a loan, not in terms of separation, just two people, okay? Gave you a loan, $30,000, let's say. He's not paying back. He was supposed to pay me back. He's still not paying back. The other guy, wants to pay him, but in reality doesn't have the money. He spent the money. Okay, well, maybe the mediator can say, how about, would you agree if he paid you $1,000 a month or $300 a month? And he's going to say no, because look, there's an inflation, and then this money is going to be completely worthless by the time he ends up paying. He says, okay. So then he looks at the other one and says, well, how about we add, 2% interest per year? Are you able to do that? And so the mediator can try to find solutions in order to favor, of course, a settlement. And the mediator is also going to tell you what the cost and the benefits of each option are. They're going to tell you, okay, if you do this, it's going to cost you this much, or this is what's going to happen. And then they're going to assist in reaching a global or partial agreement. So let's say, to give you an example, in family law. So Joe called me, there's the issue of child support for his 20-year-old son studying in computer engineering. Then there's the issue of the sofa. Then there's the car, the RSPs. She wants spousal support. There's so many matters. There's no agreement whatsoever. Well, maybe the mediator will not manage to, assist them to get a settlement on the sofa and the RSPs and not the custody in this case is 20 years old, but let's say the child support and all the assets. But maybe she's going to help him reach a settlement on certain matters, but not the other matters, okay? And so they can reach a settlement on this, and then they might have to go to court But instead of going to court on all those aspects, which is only going to make the trial a lot longer, the shorter the matters in dispute are, I mean, the less matters in dispute, well, the shorter the process, the less costly in court. And so even if you reach a partial agreement, it's still good. It's still much, much better than no agreement at all. And then there's the drafting of the agreement. The mediator will draft the agreement. And lastly, the mediator has to make sure that you did understand the content of the agreement, the consequences of the agreement, and very important, the mediator will very often and should encourage them to seek independent counsel if needed. So this is a very, very important point here that I want to make. If you go to mediation, nobody stops you from seeking independent legal advice. You can do it before, you can do it during mediation, I mean, during the process of mediation, after mediation. Nobody stops you from calling me, for instance, or calling any lawyer, okay, to get legal advice, to discuss with your lawyer, well, what should I do now? What should I tell them now? Do you think I should accept this? Are these really my rights? Are these really my obligations? Should I do this? Look at what the mediator is saying. This is what she wants. What do I do here? Can you help me try to, come up with arguments to not give her the painting? Can you help me come up with arguments to pay less child support? I mean, look, my income is this, but I have all these expenses. Do I still have to pay spousal support? I cannot afford it. She refuses to work. Is it my fault that she refuses to work? So all these things you can get answers to if you contact a lawyer independently from mediation process. Now, you can get legal advice, very important. Even though the mediator, of course, is neutral, they're going to explain to you what your rights and obligations are. He's not there to defend your rights, and he's not there to defend any party's rights. And so it's always beneficial, or very often, I would say, beneficial to seek legal advice, independent legal advice. And that will help you negotiate better in the process of mediation.
Natalia, I think this might be a good time to take our health break.
Okay.
If you don't mind, I see we're running about 10 minutes behind, and that you could add this piece to your advantages of mediation when we come back. And I've been getting some comments. We're going to definitely be talking about mediation, and the guidelines that Natalia has been expressing can be used in any kind of circumstances. I know we've been talking about divorce and custody and property, but it can apply right across the board. So we'll get more into that. If you don't mind, we'll take a 5-minute break, come back at 11 o'clock. People can stretch, get a cup of coffee or tea, and we'll continue right where you let off, stop, Natalia. And I think everybody could use a break, and I think we can compile it all and finish up nicely. And in the meanwhile, get those questions in the chat box. If that's okay with everyone, we'll just call it a short break. Be back for 11.
Perfect.
Welcome back, everybody. Natalia, thank you so much. I hope I didn't cut your flow. Going to turn it right over to you to pick up where you left off. And I think Brendan has your slides accordingly. And thank everybody for their patience. I see questions are coming in. Marvelous. So please keep your microphones on mute and get those questions in the chat box. Thanks, and I'll turn it right back to you, Natalia.
Okay. All right, so we were talking about the obligations of the mediator, and so the mediator has to act impartially and diligently, act in good faith, preserve the confidentiality of everything that is said and written during the mediation process and the information that is exchanged, and of course, my favorite, respect the principle of proportionality. So as I mentioned earlier, he cannot take any sides. He always has to act in good faith. He cannot, for instance, I don't know, try to generate more sessions, just to charge more, and also they have to preserve the confidentiality of everything that is said and written. And of course, like I said, if you argue about a sofa, you cannot spend 10 hours in arguing about a sofa. And these are basically, it's very simple, the obligations of the mediator. Let's go to the next slide, please. So, limitations of mediation. What are the limitations of mediation? Well, an agreement may not be reached. Like I said, when you go to mediation, there's no binding decision made by the mediator. You don't go there because you want a decision to be made by somebody. You go there to negotiate and try to reach an agreement amicably. But an agreement might not be reached. And if an agreement is not reached, well, you leave with no resolution and you might still end up in court. And so you pay for mediation, let's say, and you spend a lot of time. Let's say it can take weeks or months because maybe they're not available every week and you have to wait before you find a mediator who's available to, to start the sessions. And then you waited for months, let's say weeks or months, and you paid for the mediation sessions. And in the end, it turned out, that you were not actually able to settle the matter. And then you still have to go to court. So you will have incurred additional costs and maybe you even spent, too much time. Like I mentioned, some mediation sessions can be free. That's applicable to family matters, especially with or without children. And no one is there to protect the individual interest of a party. But they can seek legal advice independently. It's what I said earlier. It's very important to seek legal advice because nobody's there to defend your interest. And let's go to the next slide, please. Okay, what happens if there's no agreement? Well, you can go home basically and let the water, just calm down a bit, the waters, and you can just, let's say a few weeks later or a few months later, you can try again, maybe, or you can just call the other person and say, hello, well, your neighbor, for instance, or your brother or sister, or your business partner, and try to solve the matter again. They can address the court or arbitration. Arbitration is basically when the arbitrator that makes a decision. So that's a big difference between mediation and arbitration. Mediation is just discussing, trying to resolve a matter amicably. And arbitration is, an arbitrator is a person making a decision that's binding. And so prescription, basically, if you go for mediation and you spend a lot of time in court, well, you need to make sure that your right to start legal action is not prescribed. So usually it's like 3 years from the moment that, let's say, you were supposed to reimburse a loan, okay, that the person was supposed to pay back what what he owed you. And so you have 3 years to sue that person. And if you go to mediation, make sure that, because of mediation, you're not going to lose your right to start a legal action in case mediation doesn't work. So you can always write down in the agreement, like we mentioned, the agreement at the beginning of the presentation. You have to sign an agreement at the beginning and says, well, what the objectives are, what's the mediator going to do, who's going to pay for the mediator. Normally it's half of all those things that are provided for in the agreement. Well, you can also actually include in that agreement that the fact that we went to mediation means that we're not going to invoke prescription anymore. So we can still go to court and address this matter, even if it's more than 3 years, to give you an example. So even that you can actually agree upon. So Now it's a new thing again in this Code of Civil Procedure. It's just a few months ago, I believe, or maybe last year, they introduced a new thing just to, again, the legislator wants to promote meditation also, but mostly mediation, is the fact that even in case no agreement is reached, if the parties exercise their right to act before the courts, their case, it should not be a family matter. Their case is tried by preference, provided it is accompanied by a certificate issued by a certified mediator. So basically, if you go to mediation and you go for a session and you try to reach a settlement and to negotiate, and then mediator can give you a certificate saying, yes, you did go to mediation. You go to court when you start your legal action and you present that certificate, and you can actually get a faster court date just because you show that you tried mediation. And so what happens if the agreement is not respected? Now you have the option to address the court in order to have the agreement executed. And so what does it mean? That, well, this is I guess a limitation of mediation is the fact that even if you do reach an agreement, well, like I explained to you earlier, if there's no stamp there, if it's not homologated by the court, if you don't go to court to put the stamp on it, and you have to agree beforehand that we will go to court to put the stamp on it, to make it have the force of a judgment. But if you don't decide that, together at the beginning, in that agreement at the beginning, or even throughout the sessions, so if you don't decide that together, well, and one of the parties does not actually respect the agreement, now that's a problem, because you're going to have to go to court after that to sue the person because they did not respect the agreement. So you basically might still end up in court because the agreement is not respected. So in that case, if the agreement is not respected, then the agreement loses its confidentiality. So you should expect for the agreement to become public, basically, if you don't respect what you were supposed to do. Or if the other person doesn't respect, well, you're going to know, you take him to court, and basically there's no more confidentiality. And that's what happens if the agreement is not respected. So that's another limitation. And the next slide, please. Advantages of mediation. Now, of course, you see here Joe and his spouse, well, they reached an agreement, and the objective is always to settle. And these are the advantages. The objective is to settle, and usually they do reach an agreement. It is voluntary, so that means that there is a will to settle amicably. So they go there, like I said, committed to being honest, transparent, exchanging all the information that's needed in order to settle amicably. It is informal. There are no court and no strict rules involved. I have to tell you, in court, it is extremely formal, and there are a lot of rules. So most often than not, a large majority of cases, people do need a lawyer, because if you don't respect the rules, just for a simple procedure, basically you can lose the entire case because you just didn't respect the simple procedure. Now, the parties have control over the result. It's you making the decision. You're the one who will accept or not what the other party wants, okay? You're the one making the decision. You're in full control. Whereas in court, well, it's the judge, just this person who does not know you, who does not know the other person, who does not know the children, for instance, if it's a matter of, custody, or, all these things that the judge does not know about. They're going to make a decision. He's going to listen to your case, just a few hours of a trial. He's not going to know the history of your life and, all the emotions involved and what's best for it. No. And very often, they make decisions that are not necessarily good. They try to make decisions that are, basically correct or fair, but they're not necessarily good. And they're supposed to make decisions that let's say if it's for the children, in the interest of the children, but they don't always do, because they don't get a full picture of what's going on. In just a few hours of a trial or 2 days of a trial is not sufficient to present all the evidence. And they always say, well, the principle of proportionality, makes it so that, well, you cannot take the court's time. So the parties have control over the result in case of mediation, and the outcome is workable since the parties have agreed to it. So if you agree to something, it means, well, that you can actually make it work out. Whereas in court, the judge decides something, it doesn't mean you can actually do that. So very often you won't be able to do that. Then there's a problem of contempt of court. That's a big advantage with mediation. It is far less costly than court litigation. Again, depending on how long court takes, if it's a litigation dispute between shareholders or even neighbors, it can be between siblings, or be debts, estates, wills. It's usually long. It's usually maybe an average, I would say 2 years average, it's very long, and you always have to rely on the court's availability, and it's constantly postponed, a lot of frustration. Advantage of mediation, again, the process can be very fast, only a few sessions can be sufficient, and the parties focus on the future and not on the past. So you go to mediation because you want to maintain maybe a good relationship also with the person. You're not there to reproach him everything that he did. He's your brother. You still want to maintain, a good relationship with your family. If you go to court, let's go to the next slide, please. The advantages of mediation in family matters. The parties decide who has custody of the children, the modalities. The parties agree between themselves how to split the assets. It protects the image of the other parent, and the first few sessions are free. I just wanted to mention the family matters, but again, this is valid for most things. You don't go there to argue. You don't go there to reproach the other party everything that they did throughout, your life with them. You go there because you want to reach a settlement, because you want to focus on the future to maintain a good relationship. For instance, if there are children involved, it's really much better than to go to court constantly. They know that you're going to court, that the parents are going to court. It's not good for them. But even for instance, my case now with the siblings, they're constantly arguing in court. It really has damaged even more their relationship, because going to court and seeing your brother on the other side there of the table in front of the judge, and he says things and you say things, they're not going to leave from there happy. The family relationships are a lot more damaged in court settings. Now, I just mentioned here that in 2017, the Ministère de la Justice asked the enterprise to conduct a survey of parents after they use family mediation services, and you can see that 84% of parents reached an agreement with their former spouse, and 90% of the respondents would use the services again if needed. Let's go to the next slide, please. And the next slide is basically court litigation. And like I mentioned, this damages relationships, is very formal. Most often you need a lawyer because you don't know the rules. There's strict rules. It can last years. It's expensive, difficult, or impossible to execute. Sometimes it can lead to bankruptcies. It can destroy lives. It can damage relationships. The purpose is to win the case. Don't forget, this is actually what makes them so different. In court, the purpose is to win the case. The other instance, mediation, is to settle. So just keep that in mind. Here you go to win. You go to win. Settlement is possible once the court litigation has started, but some lawyers may not act in favor of settling the case. So even if you go to court, basically you can always settle. So you can settle right after the action, the lawsuit is started. You can settle. You can settle. I don't know, 3 months in, or you can settle right before the trial. It is possible to settle a case even if you go to court. It's just that very often, most often than not, large majority of cases, you end up spending a lot more money, of course, than if you go to mediation. And the last slide, please. So I just gave examples of basically here you see Joe, who was very happy with how he resolved the matter. And now he goes home and he's sitting on his desk. And now he's thinking of all the other problems that he has in his life. So he has business matters. He has a partner. He doesn't agree with him on so many things regarding their business, where it's going to go. Are they going to extend? Are they going to sell their product also in Ontario, or are they going to stay in Quebec? What's going to happen if they want to sell their shares? All these things. Now he's just thinking about them. The next one is, a labor matter. He has an employee, and now he has a problem with his employee. He's complaining about things. And now he's thinking, oh, maybe I can use mediation there too. And yes, he can. He can use mediation in problems regarding his business partner. He can use mediation regarding, with his employee. He can use mediation because he has a problem with his neighbor. He can use mediation regarding estate because he's arguing with his brother. He can use his mediation about the condo association, the co-owners. He has problems with the condo association. He thinks they're doing a very poor job. Then there was flooding and they didn't act they were supposed to do. There's the issue, is this a common area or a private area? Again, he has so many problems. Every area of his life has problems, and now he knows, and that's why he looks very happy here. Well, if mediation worked with his spouse, where he thought it would never work, well, it would probably work with all these matters. And you can see here how many problems actually people have, because we were just saying how many people actually do have problems, but here, look, it's not only that they have one problem, it's of all the people who experience a serious legal problem, which is 18% of the population over 18, well, 45% experienced 2 or more serious problems in the 3 years preceding the survey. And this is about it. And I look forward to listening to your question and to answering them.
Natalia, thank you ever so much. That was very informative. And as I was listening to you, I was thinking in a lifetime, we probably could have used mediation on multiple occasions. It's a relatively new method, I would say probably the last 10, 20 years that people have been benefiting from it. Certainly saves a lot of court time, judges' time, lawyers, and we know that we're even lacking a sufficient number of them to handle court cases. And saves money. So very informative. And I know that questions have been coming in. So I am going to turn it over immediately to Katia, and she will ask them. And if you think of anything that you feel that has not been addressed, please put it in the chat box and Katia will pull it up, and we'll proceed with the question period now.
Okay, hi Natalia.
Hi.
Okay, so I'm going to respect the levels of proportionality and I'm going to start things in chunks for you, okay? So I'm going to start with the basic questions. So the questions that came in was basically, what's the average cost or kind of average fees for
$130 for a mediator per hour.
130 an hour? Okay.
Yes. And what happens is that when the government actually says, okay, you have a certain number of free hours, those free hours are not necessarily, people think it's just basically going to, let's say, 5 hours of sessions. Okay, so it's 5 hours of sessions, but no, in reality, for those 5 hours, the mediator can take 2 hours to examine the file. So those 2 hours are already gone. So you do end up paying for the mediator unless you really, solve the matter very quickly.
Okay. And on average, how long does the mediation process last?
Depends on, I would say a few meetings usually. So, for instance, regarding neighbors or partners in business, maybe, of course, it can take longer. The bigger the issue, the longer it takes. Or for instance, in cases of divorce, of course, if you have so many things to settle, assets, children, custody especially, custody requires more sessions. If it's just, let's say, okay, the house, it's less sessions. I would say maybe like, let's say about 7 if it's family. I mean, if it doesn't work out, if you see it's not going anywhere, it's like 6, 7 sessions. Usually people, they say, okay, listen, it's not working. So they call me and they say it didn't work out. At one point, you kind of see where it's going. If it's not going towards a settlement, you see it. You're not gonna just like stay there for 2 years if you see that it's not going anywhere.
Okay, perfect. And a question just came in. Is there a sliding scale for the fee structure? So if you're a low income individual, do you get kind of exemptions, or is there benefits from mediation?
Okay, so that I would suggest that they call the a legal aid office that's closer to their address. I personally, I don't know. I don't take legal aid mandates. I don't know how it works with mediation. I know that I think it's probably the same, because if you find a mediator who takes legal aid mandates, probably the same as a lawyer, normal lawyer taking legal aid mandates, right? So
Right.
you're basically, if you take legal aid mandate, you're paid by the government for whatever you do for your client. So I think that the best answer is regarding that is always given, and this is what I tell all my clients. I don't want to give any information that's not perfectly accurate. So it's always best to contact your legal aid office, and if you type in Google legal aid office, you find Bureau d'aide juridique, you find the one that's related to your address. And that's the legal aid office that you have to contact. And they're going to give you an appointment. You're going to go and you're going to present your proof of income. And they're going to tell you if you're eligible or not to legal aid. And they might ask that you, sometimes if your income is low but not super low, they might ask for a contribution. So let's say you still have to pay, $30 or $50, but they're going to cover the rest, just to give you an example. So there can be just completely covered, or some contribution, or not covered at all.
Okay, perfect. So that's the perfect segue to my next question. If you need to find a mediator, can you just call any lawyer, or are mediators accredited a little bit differently?
Yes, no, mediators are accredited. So you can call the barreau. Just this is an important thing here. Maybe, it's interesting to know. Mediators don't have to be only lawyers. Of course, that mediators can be notaries, mediators can be psychologists. There are associations such as the barreau, chambre des notaires, or des psychologues, comptable, even accountants, or des comptables, right? So all these associations, they give the certificate for the person to become, for the member of their association to become a mediator. So you can have an accountant, for instance, who's a mediator. So you can call, the best way to go around this is to call the association that you think is, in a psychologist, for instance, can be a mediator. So you can call the person who you think is basically, your area there. If it's legal, then you call the barreau. If it's a psychologist, then you need to call the ordre des psychologues. If you need an accountant, call the ordre des comptables. And they're going to refer you to one, or you can just look on the internet if you want, But yes, they have to they have to have special training. It's not all lawyers who are mediators. It's not all the psychologists who are mediators. It's just the certain people are that, yes.
Okay, perfect. And in the mediation process, is there I can't read my own handwriting, a limit, a number of people who can participate in the mediation process?
It matters that other than family matters, if it's not a family matter, for instance, it's important to note you can even bring your own lawyer. So you can bring your own lawyer if you want to participate in, you want to bring your lawyer, and he's going to try to, take your side or inform you on the spot of your rights or obligations, or just to get a sense of how mediation is going. You can even have your lawyer there, okay, in a mediation session. But that does not change the objective of the mediation, which is to settle, okay? It's just that the lawyer is going to be, they can basically help you negotiate better. But in family matters, lawyers are not involved. So lawyers cannot participate there. It cannot be in that room, but you can still seek, legal advice independently, like I mentioned. It's just that in family matters, they're not allowed to be there present in that room with the mediator? Do they really want the people in family cases just to be alone and it's just them and that's it? But now I wanted to mention this. You're always allowed to have a friend, family, whatever but this also has to be agreed upon the
The term.
parties. So both parties have to agree that we're going to bring someone. If there's no agreement, then, even on that, then, so there has to be an agreement on that. If they both agree that, okay, yes, if you want to bring someone, you can, or if they both agree, no, we will never bring anyone with us, well, then that's the rule you're going to respect. You're not going to bring anyone.
Okay, so I'm going to shift to kind of specific questions about kind of examples of when you could or shouldn't maybe use mediation. So someone asked, can you use mediation for issues revolving around parking tickets or confusing parking signs?
No, so mediation cannot be used in penal law and criminal law. So any infractions and crimes, for instance, parking being an infraction, crime being, crime like theft or whatever, all like crimes and infractions, there's no mediation. And also, for instance, if you have even in family cases that involve violence, no, there's no mediation possible.
Okie dokes. And then someone asked, okay, let's say that you're going through a divorce or a custody situation.
Yes.
And hypothetically, the husband agrees to do the mediation. However, his terms are that he will only do the mediation with a mediator who's a friend.
No, like, yeah,
can
like,
do that, and B, how do you move forward in a situation like that?
yeah, so choosing the mediator who's neutral, and it has to be chosen by the parties together, is a very important step in the process. So if he does not agree to go to a mediator who's neutral, then then the mediation process is flawed. And so it cannot happen. It has to be someone who's neutral that both parties agreed upon.
Okay, so with that in mind, what happens if a situation happens with, family issues, conflict of inheritance? Let's say that one party wants to start the mediation process, but the other party doesn't. What do you do in a situation like that?
It will go to court.
Okay, so there's no wiggle room. If someone refuses.
You can never force someone to go to mediation. Of course, you can say, listen, you can present the advantages to that person. But if the person just refuses and there's no way to convince them, then it's court. It's the same thing with choosing the mediator. Like I said, it cannot be someone who's not neutral. So then if that's the condition, I only agree to go to mediation if it's this person who is my friend, is the same as saying I'm not going to mediation. So in both these instances, you're going to end up in court.
So the same thing would apply if you're in the mediation process and someone, because you have to act in good faith, and then someone says, done.
Yes, you end up in court.
You go to court, straight to court. There's no kind of more mediation processing and then mediation processing.
Yeah, like I said, actually, you can always wait and try to reestablish communication a few months later, a few weeks later, when people have calmed down. But if they don't, yes, usually if mediation doesn't work, you end up in court.
Okay, so if you end up in court, I've got a couple of questions. I'm just trying to understand the process. So you're saying that everything that's said within mediation is confidential.
Yes.
So let's say you have, during the mediation process, you had lawyers that you were kind of doing legal advice, but the lawyers weren't in the room, but they were kind of part of the process. What then happens if a situation has to go to court and there's lawyers? What happens to the mediator? What does the mediator do in that situation?
The mediator is bound also by the obligation of confidentiality. So the mediator cannot be forced by the court to go testify or by the other party. They actually, even in their code of ethics, they can never go and testify. They cannot disclose any information. that's it. So that's you don't have to worry about that. However, like I said, there's always this bemol, that if someone does not respect the agreement, then you kind of lose confidentiality, because for two reasons. It's either actually if you don't respect the agreement, or if you're claiming that there was no agreement, and then the other party can bring the agreement to court and say, what do you mean there was no agreement? Look, we just signed it here. And so if either one of them claims that there was no agreement or not on that particular point, or the agreement is not respected, in one of these two cases, you lose confidentiality.
So that can happen. And then it's
Yes, that can happen. And you
it's
can
okay.
provide, but however, you can even provide in that agreement, like I mentioned at the beginning, when you start the process and you sign the contract at the beginning, the agreement of the mandate that you give to the mediator and what everybody's obligations will be throughout the process, you can specify, for instance, that even if we go to court, you cannot present this, or if we go to court, well, then it's going to lose confidentiality. So you can even play with that. By default, the rule is that it's confidential unless you don't respect it, or unless you claim that it didn't happen. Okay, in that case, that's the default, okay, the situation. But you can always provide in that agreement at the beginning what the conditions are, what's going to be confidential. Maybe you're going to decide that it's not going to be confidential. Maybe you're going to decide that only parts of what we discuss here are going to be confidential. So the parties have the control over what's going to be confidential and not.
And so by default, what can be asked or re-asked or not asked, I guess, in a court situation. So if question, right, okay, that makes sense. Okay. Okay, so I have a couple questions here. So so let's say in matters with inheritance or family law, what happens if, say, two siblings live in different provinces or different countries and their parent lives here? So how do you go about doing a mediation process?
Well, you can do it online now. A lot of mediators offer sessions online. You can still do online, like we have our presentation now online. A lot of lawyers and mediators now, they offer services online, so you can do that.
So, but let's say, it's something to do with an inheritance. And if one family member lives in another country, is there a difference with subjects to laws, or is it subject
Oh,
to
you're asking me not how you proceed to mediation, you're asking me about the laws, how they divide the
So the first question was with the mediation, and then I'm just kind of piggybacking on it. So let's say you've got family members who live in different countries, but a will was drafted up here in Quebec, and they're in the mediation process. You got excited, I think, with that question. Or it's like, does it complicate things? The fact that there's different tax laws or what have you? Like,
no, it's not. It doesn't complicate things. First of all, who inherits what is all in the civil code. And if you have children, everybody gets an equal share unless there's a will. Here, there's a complete freedom of will, as you probably know in Quebec. In other countries, in Europe, especially, for instance, you cannot just give everything to I don't know whom, like it usually protects the children. So at least part of your inheritance will go to the children, no matter what you write in your will in certain countries in Europe. But here, for instance, it's freedom of the will. So here, if you want to give everything to just one child or everything to your girlfriend and not give anything to the children, you're allowed to. So it doesn't matter who lives where. It's the same rules apply. So it doesn't matter also where you write the will. You probably know that the wills, one kind of will is the one that's notarized, which is always better because it's easier for your children after that to execute the will. If it's notarized, it's just a bit more simple. Then you have the will that is handwritten by yourself and signed, and then you don't even need witnesses for that. It has the same legal value as the one that's notarized, it's just that it's easier process for the people who are left. And then you have the will that you can type, for instance, and then you sign after that, but in front of witnesses. So there are three kinds of wills, and all these wills are, it doesn't matter who's where, what they're going to inherit. The will is the will, and what it says in the will, that's what's decided. And it's complete freedom of the will here in Quebec.
Okay, perfect. Can you just explain again the difference between mediation and arbitration? Because I kind of feel these two words are used I can't pronounce it.
Yes.
That word, thank you. I need my second cup of coffee. But they're two separate things.
So mediation is when you go to settle a dispute or to prevent a dispute. So there's no decision made by the third party there. It's just a mediator, you know, as if you were going to a friend who is going to just help you negotiate. So it's the result of negotiation. It's really you negotiate and then you reach an agreement. Okay, you forget about this a little bit, he's going to forget about that a little bit, you negotiate. I'll give you this, you give me that in exchange, and we discuss, we negotiate, we reach a settlement, and you can leave from there with no decision, you know, with no agreement. This decision meaning no agreement. Okay, you decide not to settle in the end. Arbitration is kind of like court, but it's a more an informal court, meaning that arbitrator is kind of like a judge. The arbitrator makes a decision. You go there with your neighbor or I don't know, or a sibling or a partner, a business partner. You go together. It's very often used in business, you know, in commercial law. So you go together to this arbitrator whom you have to pay. Usually they're kind of expensive. And you sit there and it's like as if you were in court, but it takes a lot shorter time. And in the end, they make a decision, and that decision is binding. So in the arbitrator's case, they make a decision for you. You're not the one deciding. It's no settlement. It's not negotiation. It's you're presenting proofs, he's presenting proofs, and then he makes a decision, and that decision you have to respect. Whereas mediation, you go to settle, and whatever is drafted, the agreement is because you agree to it. It's negotiation. Arbitration is like going to court, but more informal court with a decision that's made at the end, rendered by the arbitrator.
Okay, so with that in mind, so if the whole ideal situation with mediation is that you come to an agreement, a settled agreement that both parties agree on, what then happens if you need to alter or amend that agreement? Can you, you just go back into mediation to do version 2? Or is it best to
there has to be an agreement to modify the agreement. There has to be an agreement to modify the agreement. There has to be an agreement to go back to the mediator also. And so if there's no agreement to modify the agreement, then you cannot modify the agreement unless you go to court or unless both parties agree to go back to the mediator. Or you can just sit at home and just modify the agreement yourself. Nobody's forcing you to go back to the mediator. If you and I now agree that instead of paying me $300 a month in my example, you know, you're paying your debt back to me, you're paying your debt, okay? And we had agreed that you would pay me $300 a month with 2% annual interest. Remember my example? And so, but now your resources are more limited. And now you're telling me, Natalia, listen, I know that we agreed on mediation, I would pay you $300, but I can only pay you $200. Is that okay? I can say, yes, it's okay. It's okay, Katya. I agree. We don't have to go back to mediation. We can just agree verbally, or we can sign that we agree from now on you're going to pay me $200. Or we can go back to the mediator, but it's not really necessary. If we already agree, there's no really reason to go back to the mediator and pay a mediator when we can just ourselves just modify in writing the agreement.
Right. Okay, your answer got me thinking about something. So let's say you have a parent who's a senior and you have a sibling, and one of the siblings has a power of attorney over that parent.
You have a sibling, and your sibling has a power of attorney over your parent, for your parent.
Yeah. So let's say there's 2 siblings, but one sibling has a power of attorney over the parent. What if that other sibling also wants to be part of that power of attorney? Can you go through a mediation process to kind of make that happen, or is that completely different?
Well, now it depends. So let's say now is the parent, when you call a power of attorney, are you talking a mandate in view of incapacity, or are you talking about a power of attorney to go to the bank and I don't know, like take money out or pay Hydro-Quebec, or because they're two very different things. Are you talking about that simple power of attorney where the parent is still capable in full capacity, or are you talking about the mandate in view of incapacity and the parent is no longer capable?
Let's play devil's advocate. Let's do both.
Okay, all right. So okay, so in the case of where the parent is capable, okay, so there's a power of attorney, and just give the power of attorney to the son who's going to pay Hydro-Quebec or help him, I don't know, like do simple administration. Okay, well, the parent, there cannot be mediation between the two siblings to decide that he's also going to have a power of attorney, because that parent is still completely capable, so he has to give a power of attorney to whoever he wants. Okay, so there's no mediation there because he's the one decided to whom he's going to give power of attorney. Now, in the case if the person is not capable, okay, now that's more complicated because it's the court who decides that the person is incapacitated. And there are two ways to decide. I mean, there are two aspects. It's health-wise and financially. So then the court decides, for instance, this person is financially incapable, or health decision incapable, or both. And so that's how it is. It's not like we don't go to mediation to decide who's going to make decisions and what kind of decisions.
Okay.
So in neither case is about mediation. One is just not possible because the parent is the one deciding to whom they're going to give a power of attorney. And then the other case, it's the court deciding if the person is incapable and health-wise or financially, what kind of decisions they're going to make for him.
Okay, so I have a final question, and it's a bit of an odd one, but I'm going to throw it out there for you, okay? Do you have any advice on how people can avoid going into mediation? Or
yeah, going to court. Going to court.
No, but what I mean is, because to me, from what you're saying, it sounds like mediation is just having a kind of therapy session where everyone is just it's a safe space where everyone just talks and gets stuff out, right?
No, I would say that no, it's not really
Okay.
the therapy, but it's like I said, also depends what kind, is it you mean legal mediation now? Like if you go to legal mediation, I think you kind of expect to see a lawyer really more than a therapist. Of course, that very often, they're used to seeing people there who are emotional and all, but they still usually they act like lawyers, trying to help people settle. So how can you avoid going to mediation? By trying to resolve the matter amicably at home first, so then usually that's the first step. It's before you go to mediation, you try to resolve the matter amicably at home. Then if it doesn't work, well, then usually you call your lawyer, and if your lawyer tells you that it sounds like there's some, will to negotiate, and it sounds like this thing that mediation could really help in your case, then usually your lawyer says, I think you should really go to mediation. And then if mediation then doesn't work, well, then again, you call your lawyer and you say, listen, I want to start legal action because it's not working.
So basically, depending on the situation, just have clear communication with people and just spell things out and write things out. You
don't want to, like, it's also strategy. If you think that you're going to go to court, certain instances are really not for mediation. For instance, abuse. In cases of abuse of elderly, abuse, I don't know, senior residences. In case of abuse, you don't really go to mediation, sometimes you can just seek a compensation. you know, if you seek a compensation, then in your case, you can sue the hospital. If you, instead of suing the hospital, for instance, because the nurse was abusing you, okay, and you don't want to file, or if you do, you can file a complaint, like a criminal complaint. You can file a police complaint, but you also want a compensation, okay, because you suffered. Well, you can sue the person in civil court. Criminal court is just separate. It's just separate. There's no mediation in criminal court. It's just that follows its own course. But you can also ask for a compensation, right, in civil court. And instead of suing the hospital in civil court to get a compensation, you can go to mediation with the hospital if they want.
There we go. So thanks, Natalia. I think I've picked your brain enough. So I'll let you chill out a little bit now. Yeah.
Okay, well, thanks a lot for the opportunity, and
don't go just yet. Thanks, Katia. Natalia, there was a comment that came in from another lawyer who is on the line, watching and listening, who says mediation services are offered without charge to cases pending before the CNESST. I think that's employees. And
yes.
Conciliation before the CRT, which I do not know what that is. Can you just spend 30 seconds and do you know when about this?
Yes. So, okay, if you go to the website of the CNESST, used to be CSST, right now it's CNESST. So these are issues regarding employer-employee. You don't have to go because not all the issues are covered by this, but many issues are, and you don't have to go if you don't want to through the CNESST. Okay, but if it's one of the issues that are covered by the CNESST, and you do want to, yes, there is a mediation service that's offered, and it helps them reach an agreement if there's conflict, and it says clearly regarding labor standards, pay equity, occupational health and safety, and accidents and occupational diseases. So for instance, it can be the fact that you're paid less than the man who does the same job as you. Okay, so differences in, okay, it can be there's an accident at work, all these things that are under CNESST. Yes, they offer mediation session. And it says that when a complaint is filed, the mediator contacts the parties to offer them their services. And they can always, they're free to accept or refuse mediation. It's not mandatory.
That's very good to know, because we
just
all
like in family matters, you know, where you have, but in family matters, you have the obligation to consider mediation, and then you also get a few free sessions. So it's the same with the CNESST. If it qualifies under one of those things that CNESST does, well, those things you can get free mediation. And,
well, that's great to know, because we all have adult children and grandchildren who are out in the workplace. So I thank you for that clarification. Natalia, I would like to thank you for all the information you've given us today. It's been a lot, and I think all of us have either used mediation or wish we had throughout our lifetime, and I think it's very valuable to have this information. So I thank you for your time. I thank everybody.
Well, thank you very much for giving me the opportunity. I hope it was informative. And it's something that we don't talk about a lot, actually. I think it's very important. People don't have a very good knowledge on mediation, and it can save a lot of time, money, and resolve disputes in the family also, and not damage relationships. So
well,
when
I think that's
great.
I think that's the key. We want to keep our relationships going with our siblings, our parents, grandparents, our neighbors, etc. So it's a very valuable service. For all the participants, there is a survey that you're going to get. Absolutely. I'm going to say it once again. Can you please fill it out when you get the link for the recording and Natalia's presentation? There will also be a link for the survey. I swear it won't take you 2 minutes to do it, but we absolutely have to have those results for our funders. The government likes to give you money occasionally for certain things they feel that has a value, but unless we can justify there is a value being offered to you, they're not going to keep up the funding. That's as blunt as that. So if you want to see these webinars continue, we need your comments back. So please, when you get that survey, fill it out, because I have to say the number of returns are very minimal compared to the participation level. So Katia is ready to pull her hair out when it comes time for final reports. So I'm pleading with you, please fill out those surveys. So on this brutally cold day, I'm going to let you all go and have a nice hot soup for lunch or whatever. And thank you once again. And the next webinar is February the 21st. No, February the 11th, on making those final arrangements and examining funeral options. Many people don't have it done, and the cost is going up astronomically every couple of months. So please, it's very good information to have. And also, what can you do following the passing of a loved one, and what documentation you need, and so you don't get yourself in a pickle. So I'm taking registrations now, so you know how to do it. Just email me. And I wish you all a great rest of the day, and I thank you for participating, and we'll see you hopefully February the 11th for our last webinar of this series. And have a great afternoon. And Kathy and Brendan and I are going to stay online.